what might be under the influence to some person would not be to another. The fact that she admitted to using cocaine the day of the incident, Ms. Bethia had the right to cross-examine her that day, about that day, even though she claims her memory was not affected. And the purpose for cross-examining is to question a witness and discover the reliability and the veracity of that testimony. And because that cross-examination was limited, the district court violated the Confrontation Clause as it related to Ms. Bethia's constitutional right to confront her witness.
As I understand it, your client believes our standard of review is de novo?
Yes.
And what do we mean by de novo?
Oh, yes, sorry. That you have free reign to review the case without any, gosh, I've never had to explain it. But it is basically a fresh view, a fresh look at the case. You are not diminished by any other case law.
We would not be bound by the trial court's decision.
Yes, exactly.
Now, I wonder if it's de novo when we have this situation. Ms. Williams did testify, and she was subject to cross-examination by your client's attorney. And under those circumstances, wouldn't our standard of review be review of an issue of fact and whether the trial court abused its discretion?
Your Honor, I believe because it is the constitutional right of Ms. Bethia, the defendant, you are allowed to review it with a fresh look. Yes, she was subject to cross-examination, but not to the extent that Ms. Bethia wished to cross-examine her about that. Unless the court has further questions.
Yeah. Well, as you know, we listen to a lot of claims of error. Mm-hmm. And a lot of times there may be an error, and we say, no one is entitled under the Constitution to have a perfect trial, just a generally fair trial. I'm not getting from you, why should I be excited about this? Why is this issue significant that the victim in a case is not allowed by a judge to testify, or the defense counsel is not allowed to ask the purported victim in a case whether she was using cocaine at the time that she was attacked? Why is this significant to this case?
I believe it was Ms. Bethia's position that the witness against her did not recall properly. She was claiming innocence. So the witness had memory problems, it seemed like she did not recall the incident at all, and then people were telling her about it, and that's how she remembered stuff. So the fact that she was a heavy drug user, used twice the day of that incident, that's important for the jury to hear so that they can view her testimony in light of those revelations on the stand. But the fact that she was not able to testify to that to the extent that that Ms. Bethia wanted to question her on that, it really did limit her right to confront that witness against her.
Well, and the crime she was ultimately convicted of is aggravated battery, which required the defendant to have an intent to do some harm, which ultimately was bodily harm, correct?
Yes.
And the only witness to the crime is the victim.
Right.
And so if the victim doesn't know what's going on because she's under the influence of drugs, that could obviously affect the guilt or innocence, her testimony, which will affect the guilt or innocence of the defendant.
Absolutely. Her powers of observation were greatly diminished, and this is the only testimony against her. There was a witness there, but she had the same kind of issues, being under a lot of medication and whatnot. So this testimony was what convicted Ms. Bethia.
Just so it's clear, there was another person in Ms. Williams' apartment who witnessed this, and that person testified at trial.
Yes.
Okay. As a practical matter, even though there was this order in limine that was preventing examination about the drug use, from looking at the transcript, it appears that the prosecutor brought it up and that during cross-examination, she admitted to using crack cocaine, and she said that it was back during the time that this happened. So didn't the jury know about these things, notwithstanding the order in limine?
Well, and the order in limine, if I remember correctly, the judge said you can ask her, was she using drugs that day? Yes. And the next question was what limited Ms. Bethia's right to cross-examine was, were your observations impaired? No. That's when he's not allowed to go further into asking her, whether she's foggy or whether,
Well, doesn't that go more towards argument that once I get it into the record that this person was on drugs at the time, then I can argue perception. Does that have to come? She had obviously testified at the preliminary, Ms. Williams had, that it didn't phase her recollection.
But that was, let me go back. And yes, that does limit his examination of her, and he can argue that in closing arguments that her capacity was diminished or whatnot. But to hear it from the witness is different than arguing it in closing arguments. And so, as he stated in the motion in limine hearing, she doesn't know to what extent she was maybe affected by the drugs unless I can get into that and ask her about it. So that's what the defense attorney was looking to do.
Did Ms. Bethia have an expert witness or anyone to testify that crack cocaine can cause certain problems?
I don't believe she did, from what I can tell from the record now.
Was the trial court correct in limiting the evidence that she was on crack cocaine because the trial court's trying to make sure that the jury only focuses on what the real issues are at the trial? And if you would let in evidence that the purported victim was on crack cocaine, the jurors might say, oh, she's a drug user, we think less of her, and for that reason, it would prejudice the state's case because their main witness is a cokehead.
I don't believe he was entirely correct in his ruling. Some cases that came through the Supreme Court that were cited in the brief, in fact, had the exact same kind of fact scenario where the complaining witness or one of the complaining witnesses was a heavy drug user, and it limited the, I believe it was State v. Beloit or Osby, one of the two, where that the defense was entitled to get into how that drug affected them by habit or that particular day, because it is the power of observation that's affected, and it's not just to discredit them and that they're a bad person, but how they perceived events are definitely going to be affected by the drugs.
It wasn't the court's concern, one of the majority, by referring to the illicit drug of cocaine. The court did not limit cross-examination as to the use of drugs and medications on that date, did it?
I believe it was kind of all-encompassing, that he could ask, if she was taking prescription medication as well, but if once she said she wasn't affected by it, then he had to kind of drop it. The cases that came through the Supreme Court about this discrediting a witness based on their drug use, there was no harm in those cases because there were other witnesses there to testify as to the typical perceptions of the complaining witness while they're on drugs, whether they're paranoid or various expert testimony as well. So because there wasn't that kind of testimony in this case, there was harm to Ms. Bethia's defense.
Wouldn't Ms. Bethia's counsel have an obligation to come forward with some, other than common knowledge that if you're on crack that might affect
Right.
you, if there was no expert that was designated or no one to make that link, how was she harmed as far as the ultimate outcome?
Well, hindsight is 20/20. We would say that he should have done this or he should have done that, but at the time he was limited by this motion in limine, and that's what he kind of he limited his cross-examination to. So I can't say how it would have changed it if he had that expert testimony or another witness to testify to that. But the fact is that this is the complaining witness, probably the most important witness to the jury about what happened that day, and the fact that he wasn't able to go into how her perceptions were changed by drugs really limited the cross-examination.
Really, if by extension, by hypothetical, if we were to extend the court's ruling, the trial court allowed defense counsel to say, were you under the influence of some types of drugs on that day? And she said yes, but she couldn't be asked what kind of drugs. If she answered the question, did these drugs affect you? And she said no, the cross-examination would be required to end, according to the trial court.
Yes.
All right, so here's the hypothetical. Ma'am, were you on drugs on the day in question? Well, you know, I was. I don't remember the names of them, but I know they're used to treat some of my mental conditions like paranoia, delusional. I'm been diagnosed as suffering from delusions, and I've got one other drug that helps me with my paranoid schizophrenia. Well, ma'am, did that have any effect on your memory? No, none at all. Under the trial court's decision, the defense counsel would just have to sit there and accept that and couldn't say, well, ma'am, if you're taking these medications for being delusional, obviously you have to have some effect. Your perception is affected somehow. I mean, I just don't understand the trial court's limitation.
I don't either. And that's what our argument is that the fact that he wasn't able to go into it with her, you know, how is she supposed to know necessarily? There was discrepancies between her preliminary hearing testimony and her trial testimony, so she obviously has some issues recalling events. Who knows why that is? And unless the defense counsel is able to go into that with her, then the jury's not going to know that either.
Of course, if I could play the devil's advocate for a moment, the order in limine is not final, is it?
I don't believe so. The judge can change that during the trial.
So was there a request made that the judge change it after some of this information evolved during the trial?
I don't believe there was a specific request for that, Your Honor.
And getting back to Judge Bruns's questioning earlier, it is quite clear that defense counsel brought up and elicited from Williams that she was taking coke,
Yes.
crack cocaine.
Yes, Your Honor.
And then there was also testimony from a police officer, the defense counsel brought up, that from the officer, that the officer had been in the area around Williams' apartment on other occasions and testified, I've been up there on illegal activities and such as illegal drug activities. And then to make sure the jurors understood that, the attorney for the defendant said, I'm sorry, for what? And he repeated it. Now, it's hard for me to understand under the facts of this case, and with no proffer of any kind of expert testimony to show the pharmacological effect or the effect on Williams, and with no request to modify that order in limine, which was not final, how your client has shown prejudice.
The specific prejudice is that he was limited in asking her questions about how it affected her. Once she said that she wasn't affected, once she said that she didn't feel like she was under the influence, he couldn't go further into that. So it's not just that she was doing drugs.
Well, but we're not, you know, defense counsel at the trial level should not have been there to try to score points at the appellate level.
Right.
Once it came up that she had been using crack cocaine, and once she gave the answer she gave, why didn't counsel, you can't answer this, but it's difficult to understand why counsel didn't approach the judge and say, Judge, I want you to set aside the order in limine based upon the testimony that's been presented.
And he probably should that, but at the time the order in limine was such that he was not able to go further into her perceptions that day.
Understand.
And there were two more issues in the brief, and unless the court has any questions about those, we'll submit those on the brief.
Thank
Thank you.
Would you state your name for the record?
May it please the court, counsel, John Bryant, Deputy County Attorney, Leavenworth County, Kansas, on behalf of the state of Kansas appellee. I would like to start with the standard of review, which the state would believe would be court's discretion. I think this is an evidentiary issue and not a confrontation clause issue. She was available for cross-examination, that being Leora Williams. She was cross-examined about drug, alcohol, and prescription medications, anything she might have been on. The fine point on the motion in limine was basically the defense trying to say she's a crackhead and shouldn't be believed. And I think if you look at the facts of the case and the testimony he elicited, you can see that that was his point. There was testimony that she had stated she had had alcohol that day. There was testimony that she was using drugs, and to get back to the hypothetical, I don't think that defense counsel was limited in saying, how does this affect you? He was limited in saying, how does crack affect you? Drugs.
But prosecutors and judges don't make those kinds of decisions. Jurors make those kinds of decisions. So if she said, I was on aspirin, and no, it didn't affect me, or I'm on crack cocaine, but certainly the jury should have some idea of what medication she's under so that the common knowledge, and you've just indicated, is that she's on cocaine and she's on alcohol, and we're supposed to trust her. She has a constitutional right, the defendant does, to have a jury consider what the defense counsel is arguing against her, to confront her testimony and make sure it's truthful and honest and accurate. And how can you do that if you don't let the jury know that she's on crack cocaine or hallucinogenics, PC, she's dropping acid and drinking alcohol, versus just having an aspirin and whatever.
I don't think,
Lipitor.
I don't think, and in your hypothetical with the paranoid schizophrenic, it's the reaction to the drug, not what the drug is. I think it's beyond common knowledge of a juror to understand the effects of crack cocaine and memory. Further, in this case, this was not a whodunit. This woman was well known to Leora Williams. This wasn't an accident where maybe she fell and hit her head. She was beaten severely. And there was another eyewitness, Carolyn Lee, who also was familiar with Miss Bethia. Miss Williams felt close enough to Miss Bethia, she thought she was family. So when you look at the elements and relevance, is the term crack relevant to her perception of what happened?
So your argument is the judge was correct because if the jury had been informed that the purported victim was a crack cocaine user, the state would have been prejudiced because they would have said, we're not going to find somebody guilty of beating up a crack user.
Yes.
Okay.
I think it's
Here's my question to you. Don't we give jury instructions at the end of the trial? And don't we sometimes give what's called limiting instructions? And how about this for a limiting instruction, ladies and gentlemen of the jury? You've heard some evidence at this trial that at the time of the incident, the victim, the purported victim, was under the influence of crack cocaine. You should not be affected, and you should disregard the fact of whether or not the use of crack cocaine is a crime. You should merely consider it as to whether or not, when you consider her testimony, as far as whether or not it's credible, believable, and accurate. What's wrong with that?
I think that would have also been fair, but my position is to represent the interests of the state, which I thought was better served with a motion in limine. Could the judge have corrected it or done something further afterwards and said, well, it's only relevant for this, but not for this? Perhaps.
But as a county attorney, as a prosecutor, you have special ethical requirements to uphold the Constitution. Wouldn't you agree with me on that?
I would.
Yeah.
Certainly.
And so, really, although we have an adversarial system and you have a very different position than the defense counsel, that's fine, that's in the Constitution too, it is incumbent on you to make sure that an individual's right, particularly the right against confrontation, is not abused.
Correct. And that is why the state's position was so specific that, and I think the record's clear, I even said, unless he has something to present to show this jury how crack cocaine affects this person, it should be limited. And
well, why can't he add, if he's not allowed to ask the question of what you're on, and the jury has no idea what she's on, oh, she was on aspirin. If you're not allowed to establish through cross-examination you're on crack cocaine, any good defense counsel would say, how does crack, if it doesn't affect you in your memory or your ability to perceive events, how does it affect you? Why do you spend so much money to use crack cocaine? What does it do to you? That would be very, very permissible as far as cross-examination. But you can't do that if the jury is sitting there and has no idea that the victim who is saying all these things happened was under the influence of not only crack cocaine but alcohol at the same time.
And we don't know that she was under the influence of crack cocaine. She said she used crack cocaine that day.
I think she said she used it 2 times, didn't she?
That's correct. But I don't know how long that effect lasts. Obviously, it must not last very long because people go out and buy it repeatedly. We don't know. And there was no attempt to lay that foundation.
But that's because the court precluded that.
I don't believe so. I think that the court allowed him to ask questions. He could have asked simple questions of the officer. Did she appear to be under the influence? That was not prohibited.
Under your view, he could have said to her, ma'am, you were under a mystery drug. How does that mystery drug affect you? And how's that going to leave the jury? How's that? I mean, that's almost silly.
But I think you look at the facts of this case and the hypothetical, but the facts of this case, what is the relevance of the foundation that he was laying? He did not ask if she was under the influence of any person that observed her. So if he doesn't ask that, then what is the relevance of then saying, but you were using crack? That was the state's position. He did not attempt to lay any sort of foundation for her appearance to be under the influence. He got that information from the officer, never asked the officer, when you talked to her, did she appear to be under the influence? And what's more, he didn't have anybody to testify about what crack cocaine might do, or even in preliminary hearing didn't ask her about her history with crack cocaine.
Is it your position that if defense counsel had said in the motion in limine, Judge, I've got an expert on cocaine addiction, a pharmacologist, and that pharmacologist is going to come in, doctor of pharmacology, KU Med Center, and he or she is going to testify that cocaine alters a person's state of consciousness, that taken with alcohol, a person can lose all sense of reality such that they do not perceive what they think they perceive. Are you saying that the court should then have allowed defense counsel to ask the type of drug that she was on?
In the motion in limine hearing, that was, I believe, 100% of my opinion.